Hello, my name is Plowden and this is a lecture for the European Criminal Justice Observatory. What I've been asked to talk about is what you can expect in practice in the courts in England and Wales, a common law system perspective. Can I start by giving you a little bit of background about me? I'm a Professor of Law at the University of Derby, where I'm also Pro-Vice Chancellor. But in addition to being an academic lawyer, I qualified as a solicitor doing mainly criminal defence work, and I'm in practice as a barrister. I'm also the academic advisor to the Law Society of England and Wales's Criminal Law Committee. It's obviously quite a tough ask for me to cover the entire of the English criminal justice system in about 30 minutes, but we'll give it a go. What I plan to do is to start off by talking about the common law system and about what that means. I'm also going to touch on the fact that England and Wales has an adversarial system rather than an inquisitorial one, and I know that again that is different from some of the European states. The second section will look at the criminal justice process, and I'm going to divide that into a number of subsections. The first will deal with the process from the arrest of a person, the taking of them to a police station, up to the point where they are charged with a criminal offence. The second stage will look at the early stages of the court process, and in particular how cases are prepared for trial. The final stage will deal very briefly with trial and with sentencing. The third and final section of this talk will deal again very briefly with some of the core evidential rules which drive our criminal justice process. It will deal with confessions, with the concept of hearsay evidence, and with the use of experts within the criminal justice system. It will also deal with the right of silence and the fact that adverse inferences can be drawn at trial where a person exercises that right of silence. This is a broad overview, however, and there will be some topics that I don't cover, and I will try to touch on these at the end of the talk so that you know where you need to seek further information. So can I start, please, with the idea of a common law system? In contrast to civil law systems, in a common law system, much law is made by the courts themselves. In some cases, the origin of the law may be in legislation which is passed by Parliament. An example of that is the Theft Act 1968, where Section 1 provides that theft is the dishonest appropriation of property that belongs to another person with intention to permanently deprive them of that property. So you have a fairly comprehensive definition laid down by the statute. But when you dig down into that, you find, for example, that the statute is almost silent about what the word dishonest means. The courts, therefore, have stepped in many decades ago, and the leading case is one called Gauche, where the courts provided that in order to decide whether somebody has been dishonest or not, you have to ask two questions. The first is an objective test. Would an honest and reasonable person regard what the defendant has done as being dishonest? And the second arm of the test is, would the defendant themselves realise that this objective observer would regard what they did as being dishonest? So there you have an example of the common law providing for gaps in the statute and laying down precedent which must now be followed by all the lower courts until it is overturned by a court at the same level, or more likely by a higher appellate court, whether the Court of Appeal or the Supreme Court. But we do also have some offences which are purely the creation of the courts. For example, kidnap is not an offence which is laid down by any legislation at all. It is a 17th century offence created by the courts at that time, fleshed out by subsequent courts, and now with a venerable history and a huge amount of case law, some of it contradictory, which defines what that offence is. And when we come to look at codifying that law, moving it into a statutory format, we find that 150 pages of densely argued text is needed in order to try and capture what the law currently says and what a statutory provision might say in its place. So the common law does provide a different way in which criminal justice practitioners have to deal with precedent. The second feature you'd find in England and Wales is that we have an adversarial system of criminal justice. The example I often use comes from the writer John Mortimer, where he had a judge ask an advocate, "Mr. Smith, am I not to hear the truth in this case?" To which the advocate replied, "No, your lordship is to hear the evidence in the case." So within an adversarial system, the prosecution adduce the evidence which they say will show that the person is guilty of an offence beyond any reasonable doubt. The defence may themselves advance a positive case, or they may simply seek to undermine the prosecution case to show that it is not capable of belief or that there are reasonable doubts. The judge does not step down into the arena. The court does not conduct an investigation. Ours is not an inquisitorial system, but one which relies upon the combat of evidence produced by the two sides, the prosecution and the defence. And again, you will see that this has a significant impact on the way in which our process works. It is worth just touching at this point on the basic court structure that you would encounter in England and Wales dealing with criminal justice matters. The two key courts are the Crown Court, which hears more serious offences and where a judge will sit with a jury of 12 members of the public. The next level down is the Magistrates' Court. There you will either encounter a single professional judge, known as a district judge, who will hear cases, or you may find yourself dealing with a bench of lay people, 3 justices of the peace, who do not have specific legal training, but will be advised by the court's legal advisor on any issues of law upon which they need assistance. The magistrates' courts deal with well over 90% of the cases that are heard in England and Wales. Some very trivial matters, traffic offences typically, minor assaults, minor public order matters, can only be heard in the magistrates' court. Some very serious matters, murder, manslaughter, rape, very serious sexual offences, can only be heard in the Crown Court. But there is a raft of what are called either way offences, typically offences of dishonesty or drugs offences, mid-level assaults, which can be heard either in the magistrates' court or in the Crown Court, and where the defendant ultimately will have the choice whether they wish to have their case heard in the lower magistrates' court with its limited sentencing powers, or whether they wish it heard by a jury, but in a context where more severe sentences can be passed. So I'd like to move now to stage 2 of this talk and to look at the basic stages of the criminal justice process. I've divided this into 3 stages. What happens up to the point of charge? So arrest, what happens at the police station, and charge itself. The second stage will be to look at what happens in the early stages of the court process. What happens with bail, what happens with disclosure of information. The third stage will look at trial and at sentencing. So the first stage, pre-charge, is arguably the most important, because this is where the evidence is gathered and where the defendant is first brought to the police station and is interrogated. So if we start with the process of arrest, historically the police have had a power to arrest, but only for the more serious offences, or for offences where there is some good reason why they had to arrest, because, for example, they didn't know the suspect's name or address, and therefore could not send them a summons to attend the court. More recently, the law has changed, and it has given the police an unrestricted power of arrest. The police can arrest for any offence, no matter how serious or how trivial. There is a counterbalance to this. Code G of the Police and Criminal Evidence Act, the act which is the mainstay of the arrest and interrogation process, provides that the police can only arrest where it is necessary to arrest. Code G states that the power of arrest cannot be used simply because it can be used. The police are supposed to always exercise a judgment as to whether it is necessary to arrest. The reality is that the courts are very reluctant still to second guess operational policing decisions. They tend to allow the police a lot of discretion, and so many defence practitioners have doubts as to whether this necessity test is really being effectively scrutinised by the courts. There are, however, some aspects of the English and Welsh system which seem to me to be best practice. For example, once somebody has been arrested, the law provides that they should normally be taken at once to a police station. The rationale behind this is that so long as they are on the street or in a police car or a police van, it is impossible to scrutinise the treatment that they are receiving. Once they arrive at a police station, they are captured within the system and their well-being can be ensured. The police are not supposed to question a person, for example, until they arrive at a police station, until they have access to legal advice. Once somebody does arrive at a police station, they will normally be booked into the system by an independent custody officer who will decide whether there are grounds to detain the person, for example, in order to obtain evidence by questioning them. And at that stage, the custody officer will open something called a custody record. And this is no more or no less than a pure piece of administrative work on which a custody officer must record every single thing of importance which occurs at the police station in respect of that detainee. This very simple safeguard is one of the most powerful safeguards we have against abuse at the police station. It should be possible to track exactly what has happened at any given point in the police station and to spot any gaps in that record. Commonly what will happen at a police station is that somebody's fingerprints will be taken and increasingly a DNA sample will be taken. But what the police really want to do in the majority of cases is to question a person. The police in England and Wales are very reliant on the obtaining of evidence by questioning at the police station. The detainee at the police station does have a right to legal advice, but there are worrying signs that increasingly that legal advice is provided by call centres rather than by a solicitor or his or her representative attending the police station in person. If a detainee is going to be interrogated by the police, then that questioning process will be audio recorded, and there are moves to introduce video recording. Again, this has proved a crucial safeguard against police misconduct, but it also acts in the interests of all the parties because it is now very rare for there to be debate about what has been said or done during the interrogation process. 2 copies are kept. A master copy is sealed and cannot be opened without the consent of the court, thereby ensuring that there is a copy that cannot be tampered with. Further copies will be taken from the second copy. The charging decision will be taken either by the police if they decide that they have sufficient evidence to justify a charge, or in more serious cases by the Crown Prosecution Service, which is the independent branch of government which proceeds with prosecutions. Because there are time limits under which a person can be detained at the police station, 24 hours in the first instance, which can be extended for more serious offences to 36 hours if a senior police officer gives his consent, potentially up to 96 hours or 4 days, but only with the consent of the courts. Because these time limits exist, it is not uncommon for the police to find that they need to stop the custody clock, to stop the time limits from running in order to obtain further evidence. They will do this by bailing the person from the police station to come back at a later date, at which point the time limits will start running from the point at which they previously finished. Ultimately, however, the police or the Crown Prosecution Service will need to decide if they have sufficient evidence upon which to found a charge. And if they charge the person, they may either summons them to attend court, or they may take them to the next available court. So that is the pre-charge process. Arrest, detention, questioning with a custody record, with access to legal advice, potentially by telephone, but traditionally by a solicitor or a solicitor's representative in person. There is a right to silence during the questioning process, and I'll talk more about that when we look at issues of evidence. I'd like to move here to the second stage, which is preparation for trial. So we're now talking about somebody who has been charged. They will be produced at a magistrate's court, the lower of the two levels of criminal courts. If they are charged with a very serious offence that can only be heard at the Crown Court, they will only appear once at the magistrate's court, and they will be sent immediately to the Crown Court for all further hearings. Now, there are a number of things that need to be dealt with. There's the issue of how the case is going to be funded, legal aid. That is sufficiently complex that I don't plan to cover it during this lecture. There is a right to legal aid funding for the majority of criminal offences, certainly those of any seriousness, but there are moves to introduce means tests so that there is an assessment of whether the person is capable of paying for their own defence. This is an area where changes are happening all the time. After the issue of funding, the next issue is bail. What do we do with this person while we are waiting to bring the matter on to a full trial, while the case is being further prepared by the prosecution and by the defence lawyers? Bail in England and Wales is generally compliant with Article 5 of the European Convention on Human Rights. There will normally be a presumption that the person will be granted bail unless there is good evidence that either they will commit further offences, that they will interfere with witnesses or the course of justice, or that they will abscond. In some circumstances, exceptional circumstances, it may be possible for somebody to be refused bail for their own protection. But the major piece of work that has to be done in preparation for trial is obviously the taking of witness statements and the gathering of any further evidence which the prosecution require and which the defence respond to. And it is here that the adversarial nature of the English criminal justice system makes life complex. There is no central file, there is no court file of evidence which is shared between prosecution and defence. The prosecution, with all the resources of the state behind it, will have gathered its own file of evidence, and there are then an increasingly difficult series of rules which say when the prosecution should share that material with the defence and when they should not. Equally, there are complex rules being put in place around case management, requiring the defence to reveal what the issues are going to be within its case. Now, for those of you from Europe, this may seem very obvious, but within England and Wales this is very controversial, because our approach has always been that within an adversarial system, it is for the prosecution to prove its case without any assistance from the defence at all. And traditionally the defence have been able to say nothing right up to the point of trial, and only at that point to reveal on what basis they intend to challenge the prosecution. Increasingly, case management rules say that criminal justice is not a game, and that the defence must reveal to the prosecution and to the court what the major lines of attack will be, so that both sides can prepare for the hearing. This is controversial, and it is a major culture change for defence lawyers, particularly because, as any defence lawyer anywhere in the world will know, our clients are quite often reluctant to give us a full account of their defence, and we may find that their defence changes over time as they have increased sight of prosecution evidence. Under our system, the defence will normally have access to any material which the prosecution intends to use as part of its case. What is less clear is all the rest of the material which the prosecution has in its possession from the police investigation and which it does not intend to use. Our rules say that this should be released to the defence if it will either assist the defence case which has been disclosed or will undermine the prosecution case. So, for example, if the prosecution have evidence from a witness to say that this was not the person who burgled the house, that clearly undermines their case and it should be released to the defence. It is increasingly clear, and it has been clear for a decade or more, that this system does not work in practice, and miscarriages of justice do regrettably occur. The final thing I need to touch on in terms of preparation for trial is the decision for those cases which can either be heard in the Magistrates' Court or the Crown Court. And just to remind you that in those either way cases, like theft, which can be heard in either court, there will be a decision which the defendant needs to take about whether he wishes to have this case heard in the Magistrates' Court, which tends to be quicker and less stressful, but which most defence practitioners feel is more likely to convict than a jury, but which has limited sentencing powers. Or does he wish to go in front of a jury who defence practitioners generally feel are more likely to be sceptical, to really wish to test prosecution evidence, but in a court which, if he is convicted, he will face a higher level of sentence, potentially. So we've dealt with pre-charge, we've dealt with trial preparation, very briefly. Issues there of bail, of funding, and of disclosure. I'm going to turn very briefly to the trial itself. Within the trial, the prosecution will start. It will open its case. It will generally have an opening speech. It will call witnesses, and the expectation is that for any evidence which has not been agreed and which is controversial or important, live oral testimony will be given, although there may be increasing use of video links so that witnesses can give their evidence elsewhere than in court itself. The person will be examined in chief, and the principle there is that the prosecution will not ask leading questions, questions which suggest the answer. There will then be a cross-examination by the defence advocate, and there is a limited opportunity for the prosecution to then re-examine. Once the prosecution has called all its evidence, the defence may make a submission that even on the evidence so far, there is no case for the defendant to answer. But if the judge decides that there is a case to answer, there is then an opportunity, but not an obligation, on the defence to call evidence itself. The defendant has a right to silence, does not have to go into the witness box and testify, but if he fails to give evidence, if he fails to go into the witness box and to testify for no good reason, then the court may draw inferences against him from his failure to do so. What happens in court will be determined by whether we are in the Magistrates' Court or the Crown Court. In the Magistrates' Court, you either have a single judge who will rule on matters of law and fact, or you will have 3 lay justices of the peace who will have a legal advisor to assist them with the law, but will make up their own minds on issues of fact. In the Crown Court, however, matters are more complex, because there will be a judge who runs the trial and gives rulings to the jury on issues of law, but the jury of 12 people will hear the evidence and will make their decision based on that evidence. If a person is convicted, there are different sentencing powers, but it is worth making clear that the most common punishment in all the courts is a financial penalty, a fine. There is a range of community penalties for more serious offences, and ultimately there is the power of imprisonment. At present, magistrates can only imprison for up to 6 months for a single offence. The Crown Court has an unrestricted sentencing power other than any restrictions which are laid down by statute. There is a right of appeal. From the magistrates, you can appeal to either the Crown Court or in some cases to the High Court. From the Crown Court you can only appeal to the Court of Appeal itself, and you can appeal either against the conviction or against the sentence that you have received. There is a final safety net, the Criminal Cases Review Commission, which can hear cases which have been to appeal, which will investigate those cases, and which will decide whether there is a potential miscarriage of justice which is so serious that it justifies referring the matter back to the Court of Appeal for consideration. But that is a safety net system. So I've covered with you the inquisitorial and common law elements of our system. I've covered with you the basic trial process and the preceding pre-charge process. What I'd like to touch on, if I may, very quickly, is the rules of evidence which underpin the English and Welsh system. And I'm going to talk about confession evidence, the right to silence, character evidence, hearsay evidence, and experts. I will cover these, however, very briefly, just so that you understand the very basic principles which underpin each of these. Let me start with confessions. In the English and Welsh system, a confession is sufficient basis upon which to convict somebody. We do not require any corroborative or supporting evidence. A confession, which is an adverse statement made by the defendant, can and generally will be used against them. That is why the police focus so hard on the interrogation process at the police station in order to get confession evidence. A confession can be excluded if it has or may have been obtained in circumstances which render it unreliable, perhaps because of something said or done by the police. They perhaps have breached Code C of the Police and Criminal Evidence Act in the way that they have conducted themselves at the police station, or at the point of arrest, or during the interrogation. A judge therefore has the power to exclude that evidence, and must do so unless the prosecution can show that the evidence of the confession is not unreliable in consequence. It's also worth making the point that there is a general fallback power on any court under Section 78 of the Police and Criminal Evidence Act to exclude evidence if admitting it would have, and I quote here, an adverse impact on the fairness of the proceedings. In other words, if this evidence would mean that somebody did not have a fair trial, then the court will exclude it. So confessions are an important part of the English criminal justice system. Similarly, there is a core right to silence to protect the defendant from having to make a confession or make statements that are adverse to his interests. But this has been substantially eroded. So a person who is arrested and is being questioned by the police at the police station is normally entitled to say nothing. And normally that cannot be held against him at any subsequent trial. But the proviso on that, the changes which were brought in during the 1990s, provide that if the defendant at his trial relies upon facts in his defence, which he could and should have mentioned when he was being questioned by the police, then adverse inferences can be drawn. In short, the jury can be invited to conclude that the reason that the defendant didn't put forward his story when he was being questioned by the police was that he knew that it wouldn't stand up to scrutiny at that point, or he needed more time to make up his story. So the defendant does have a right to silence, in the same way that he has a right not to testify at his own trial. But if he does exercise his right to silence, it can be used against him at trial. Third thing in evidence I wanted to touch upon is character evidence. And again, this will be a problem in many member states of the EU. What do you do where you have somebody being brought in front of the court who has previous convictions? How do you avoid the court convicting them simply because they have done this sort of thing before? How do you ensure that a jury, for example, looks at the evidence in this case and isn't distracted by previous bad character? Our rules in England and Wales changed fundamentally about 5 years ago. They now provide a whole range of mechanisms for admitting evidence of a person's bad character. For example, if he has committed similar offences in the past that have probative value, then those offences are likely to be adduced as part of the prosecution case. If the defendant attacks a prosecution witness by attacking their credibility or their reason for giving evidence, then again it is considered only right that the court, that the jury, can hear of the bad character of the person who is making those assertions. If the defendant asserts that he is of good character, again his previous record can be adduced at trial. So there are a number of circumstances in which the defendant's previous record will now be adduced at trial, and there is a huge amount of appeal level case law considering whether that has been done correctly or not. Equally, there are tight restrictions on referring to the criminal record of other witnesses. So we can have a strange situation in which a defendant with a previous conviction for robbery has that conviction put in front of the jury, but a witness with a previous conviction for dishonesty does not have that conviction made available to the jury. There is something worrying about this imbalance. Two more quick points. Hearsay evidence. The law does allow for evidence to be given other than by oral testimony from a witness present in court or by video link. It is not uncommon for documentary evidence to be adduced, either because it is business documentation where there is no reason to doubt its veracity, or because there is some good reason why a witness cannot be produced in court. There is currently something of a conflict between the UK Supreme Court and the European Court of Human Rights in Strasbourg. As you will know, Strasbourg jurisprudence indicates that hearsay evidence should never be the sole or main basis for convicting a person. The UK Supreme Court has said that this will not always be the case and has declined to follow the current jurisprudence coming from Strasbourg. So we will need to see how that is resolved. Finally, expert evidence. The normal expectation is that a judge or a jury will be able to make their own mind up on the evidence that they hear. So only where there is a highly technical matter, whether it's medical, concerning mental health, or scientific evidence of some kind, will we accept expert evidence being given at trial. An expert must have suitable qualifications or must be able to convince the court that they are in a position to explain evidence that the court otherwise would not fully understand. So those are the core principles of evidence. I've touched on them only very briefly, but you can see how they fit with our justice system. Confessions, the right to silence, character evidence, hearsay, and experts. I'm about to finish now, but it may help if I just set out a few things that I haven't covered. The first is I haven't really discussed the interface between the English criminal justice system and human rights law. The second is I haven't really discussed the way in which the legal professions operate in England and Wales, the difference between barristers, solicitors, prosecutors, legal executives, the fact that we do not have a career judiciary. And I haven't discussed the various ethical considerations that determine particularly how we as defence lawyers, but also how prosecuting lawyers must respond within a court environment. And I haven't really gone into the detail of any funding arrangements either. However, I hope that this has given you a core overview of how English and Welsh criminal justice operates within a common law system. Thank you very much for watching this.